Welcome everyone, this is Amer Mushtaq from U Council. Today we'll talk about the difference between an employee and an independent contractor. We had done a lecture before, which was part one of this, in which we had discussed the implications of being found an employee or an independent contractor or a dependent contractor, and we had talked about it. We promised that we will do a lecture on how do you determine whether you are an employee or an independent contractor, and this lecture deals with that. Before we begin, we'll start with the disclaimer that this course is not legal advice, so if you have any specific questions, please contact your lawyer or paralegal. First question that comes to mind is, who gets to decide whether you are an employee or an independent contractor? Is it the employer, the company that you want to work for or you are working for? Do they get to decide what is your status? Is it the employee or you, the independent contractor? If you wish to be termed as independent contractor, do you have that choice or say in the nature of that relationship? Is it the CRA, the Canada Revenue Agency, that gets to decide whether you are an employee or an independent contractor? Is it WSIB, Workplace Safety and Insurance Board? Do they get to decide, or other entities like Employment Insurance Act or Canada Labour Code, so Ministry of Labour, Canada Pension Plan? All of these have stakes in the decision of whether you are an employee or an independent contractor. So who gets to decide how your relationship will be defined? Ultimately, it's the courts. So the court has the final authority to decide whether the nature of relationship is that of an employee or is that of an independent contractor. So if courts get to decide, what is the legal test? How do courts decide the nature of relationship? So this legal test has different names. Often it's called control test. Actually, most often it's called control test. Sometimes it's called integration test. Sometimes it's called business organization test. Whatever the name may be, what is the purpose of this test? The purpose of the test is to decide whose business is it. So if you are claiming to be an independent contractor, then is this really your business or not? That's what the court is trying to get at. And in order for the court to decide, the court considers, it applies sort of a fourfold test, and that fourfold test has these components. So what is the degree of control over you if you are claiming to be an independent contractor by the company that you're working for? That's one consideration. Who owns the tools, the ownership of tools? And by tools, I mean, if you require, let's say, a laptop to provide your services, do you use your own laptop or does the company provide you with that laptop? So and we'll talk about it in a bit more detail. Whether you have a chance of profit from this engagement, this work that you will do for the company or this entity, and whether you undertake any risk of loss if you are not able to deliver, or if you are not getting any work, are you losing any money? So those are sort of the four components of the test. And in application of these, in order to find out how all of this plays out, the court looks at a variety of factors that relate to your circumstances, that relate to your nature and scope of your employment or work relationship. So we'll talk about each of these factors briefly, and then this is not an exhaustive list. There could be many, many more factors, but this will give you an idea of the kind of things that the court considers. So number one, whether your position permanent or contractual. Are you there only for 3 months, 4 months, 6 months or so, and at the end of that contract, the relationship ends, or are you working on a permanent basis with that company? Are you a full-time employee? Are you a part-time? Is your relationship full-time or part-time? That is a consideration. Are you allowed to work for other entities? Can you have multiple tasks from multiple companies at the same time? I mean, if you imagine, let's say, a general contractor may have, may be working on 3 or 4 houses at the same time, or may have lined up other work and maybe allocating his or her resources based upon all kinds of commitments with all kinds of companies. So if you are working for just only one entity, only one company, then that sort of sounds more like an employment relationship than an independent contractor relationship. what is your relationship? Do you occupy a key role in the business? Are you is your title CFO of the company? And if that's the case, then that sounds more like an employment relationship, not an independent contractor relationship. What about your work schedule? Who gets to decide your hours of work? If the company that you're working for dictates that you have to show up at 9 o'clock and work till 5 and you have 2 breaks in between, that's a lot of control over your scheduling, and which indicates more like a employee relationship than an independent contractor relationship. But keep in mind that when I'm talking about all of these factors, not one factor is determinative, right? So keep in mind that, let's say if we're talking about key role in business, I mean, I personally know some lawyers who work as general counsel on a part-time basis for a number of companies, as long as there's no conflict of interest, and they may be able to do that as an independent contractor, even though the role is a key role in the company. So not one factor is determinative. The court is going to look at all of these factors and see what kind of theme arises out of these factors, and what kind of relationship comes to surface. So work schedule is an important factor. Then the court will consider the location of work. Are you required to show up at a certain location and work from there? Can you choose different locations of work? Can you do some work from the office? Can you work from home? Can you work from out of country? That's a factor to consider. Ownership of tools, which I touched upon earlier, is again, who gets to bring in, who owns the tools of work. So for instance, if you are a plumber and you're doing a job at one place, you will generally bring your own tools. You will have your own van, and you will have all kinds of plumbing tools that you use in providing your services to an entity or a person or a company. So ownership of tools is relevant, and it depends upon the kind of work you do. I mean, you may just be doing consulting work. For instance, if you're an engineer and you provide certain designs, are you using your own software? Do you own the CAD, the computer design software, and then do you create the models on your own software on your own laptop and then deliver the work product to the company? Are you actually utilizing all of the company tools? And tools includes all kinds of things. Are you provided a desk? Are you provided a phone? Are you provided a computer? Are you provided a uniform? Are you provided safety boots? All of these things are considered tools. And who owns the tools? If the company for which you're providing services owns the tools and you don't own those tools, then that kind of indicates a relationship as an employee relationship, not as an independent contractor relationship. What about company meetings? Are you required to attend all of the company meetings, whether they are administrative, whether they are operational nature meetings? And if that's the case, then that sounds like an employee relationship. An independent contractor may attend meetings here and there based upon his or her project, but would not be attending routine meetings with the company. So that's another indication. What about your remuneration? As an employee, your income, your salary, your remuneration is fixed. Whether you do a good job or a bad job, you still get your salary. And the employer is actually taking the risk on you and hoping that you will deliver and you will be worth the money that is being paid to you. But as long as you're employed until the last day of your work, you are entitled to your salary. But in an independent contractor relationship, your remuneration may not be fixed. It may depend upon what products you deliver and whether you deliver it on time. And so the scale may be different, and that reflects the relationship as an independent contractor. What about group benefits? If you are an employee, generally employees get group benefits, medical, dental, short-term, long-term disability, and independent contractors usually would have their own benefits if they would like to benefit from that kind of plans, but would not generally be under the company's benefits plan. What about your ability to hire and fire employees for the company? If you can hire and fire employees for the company that you're providing services, that kind of shows that the relationship is that of an employee, not of an independent contractor. On the other hand, if you're an independent contractor, can you subcontract the work, right? Or can you send somebody else in your place? If that's the case, then you're more acting like a company, more acting like an independent contractor. So that is a factor that may show that you're an independent contractor. What about your ability to manage companies' employees? If you're managing companies' employees, if you're writing their evaluation reports, if you're doing their scheduling, that sounds more like an employment relationship. You sound more like a manager of the company as opposed to an independent contractor. What about paid vacation? If you get paid vacation, usually employees get paid vacation, not independent contractors. What about financial risks? Again, financial risk is important. Do you have any risk in this relationship? Sometimes when independent contractors are running operations, they have costs to run their own operations. For instance, they may have their own office, they may have, internet, they may have phone connections, they may have other, software licensing and whatnot. So whether you are getting paid from a company or not, whether you have a contract or not, you are paying those expenses. And so there is a risk that you may not get contracts, you may not get some job, and you still, may end up losing money. So there are financial risks associated with independent contractor work, but generally speaking, there are no financial risks for an employee. Employee is entitled to his pay regardless of whether the employee delivers any results or not. Do you have any flexibility in deciding how the task that is assigned to you is completed? So, let's say if you're an independent computer programmer, in that relationship, the company comes to you and says, we need software that records our customers' data, and then you are let loose and you go and decide based on the framework that is provided to you, based on the requirements of the company, you go and decide how that software is developed. So there's a lot of flexibility in that. But if you're an employee, you have limited flexibility. You are being questioned at every single step. You have to follow specific directions in terms of what is required of you. Are you allowed to work for others? If you can work for multiple entities, then that sounds like an independent business, sounds like an independent contractor relationship. If you're working for only one company, that sounds more like an employee relationship. What about intention of parties? So this is where your intention comes into play. When you were hired, or if you are negotiating an agreement or contract with a company, what is the stated intention of you and the company that you want to work for? If both of you are agreeing that this is an independent contractor relationship, the court will consider that. That's not a deciding factor, but the court will take that into account and consider why you chose to label yourself or your relationship as an independent contractor relationship. So it is a factor, but not the deciding factor. So I want to go back quickly to all of these factors and say that it is not, all of these factors are considered, and then there will be a theme that will emerge. So not one factor is determinative of the relationship. So when court considers all these factors, or many, many more, how do they apply the test? And so one thing I want to tell you about the application of the test is this spelling mistake. It's test, not text. Flexible approach towards the application. So what I mean by flexible approach is that if there are 20 factors the court has considered, it's not going to be that if 12 out of 20 show a check mark of independent contractor relationship, then you are an independent contractor. So it's not done in that sort of fashion, but the tests are applied, all the factors are considered, and then the court will see whether a theme emerges from this. Does the relationship, looks like an employment relationship or an independent contractor relationship, and that's how the court will apply the test. Another important part, and very important part to keep in mind, is that the application of this test is purposive. And what do I mean by that? I'll give you an example. So court may be considering whether you are an employee or an independent contractor with respect to some specific legislation. So for instance, if CRA has claimed that your tax deductions were improper because you were not an independent contractor but an employee, then the legislation that is being interpreted is Income Tax Act. If you have filed a complaint with the Ministry of Labor that you should have been entitled to vacation pay or public holiday pay because you were an employee, then the legislation that is being interpreted is Employment Standards Act, ESA 2000, which is in Ontario. So when I say purposive, what court does is court looks at the purpose of that specific legislation and then decide on based upon that purpose, decides whether you are an employee or an independent contractor. And why that's important. So I'll give you an example. Employment Standards Act, Employment Insurance Act, Workplace Safety and Insurance Act, WSIA for WSIB things, Occupational Health and Safety Act, Canada Pension Plan. All of these legislations have a lot of rights for employees. They are designed for the protection of employees. And so when the courts are interpreting those legislation which are for the benefit of employees, the court looks at the definition of employee more broadly and try to capture as many people as possible so that they can benefit from that legislation or protection of that legislation, right? So that is why a person may be considered by courts an employee when the court is interpreting Employment Standards Act or Employment Insurance Act, but may consider you an independent contractor if it's considering Income Tax Act. So one person could be defined as an independent contractor in one legislation for the purposes of one legislation and an employee for the different legislation. So that's how these tests are. This test is applied in a flexible way, in a purposive way. So a quick summary. Generally speaking, if you have no financial risk in this game, if you have no financial risk in this relationship, if you work under very specific control and direction of the company that you work for, and you work for one company, the chances are you are most likely an employee. So keep that in mind, just sort of an overall theme that emerges from it. But like I said, these are not the three factors. The court looks into a variety of factors to come to its conclusion. Now, one thing that often people have asked me is, look, I'm actually incorporated and I'm providing services as a corporation, so I'm definitely an independent contractor. Maybe not, and not necessarily. The fact that you are incorporated and you're providing services as a corporation is one factor. It's not the deciding factor. So the court it may or may not matter. The court may still find you an employee even if you're incorporated, excuse me, and you're providing services as a company. Now, we talked about CRA. Usually, I mean, a lot of people, when they like to assign their position as an independent contractor, one of the purposes they want to take control of their taxes. They don't want to pay CPP, EI, and they want to deduct certain expenses which are only available to businesses, to independent contractors, and not to employees. So it's important to look at CRA's view. I've provided a link here that you can check out, which provides the CRA's position. How do they determine what is the nature of relationship? How do they apply the test? The test that they apply is not different than the control test, but there are specific examples that CRA has coded. By all means, review that. And if you absolutely want to be sure whether the nature of your relationship is going to be independent contractor or not, you can actually seek an advance ruling from CRA. So basically you send a document to CRA and say, I am going to provide these services, and am I considered an employee or independent contractor? And based on that specific job description, CRA can give you an advance ruling whether you are an employee or an independent contractor. So hopefully this is helpful. We'll continue to post more lectures because we notice that there's a lot of interest by people in understanding this relationship. And so probably in the next lecture, what we'll try to do is talk about consequences of, what are sort of the negative consequences of if you are considered an employee as opposed to an independent contractor, and what happens. So we'll cover maybe that topic or other related topics. If you have any specific questions on these topics, please send us your comments. Please ask us questions, and we will be sure to add that in the next lecture. Thank you for watching.